A corporate board relies on equal access to information. 7 directors sit at a table to govern. Now, imagine one of those directors is physically barred from confidential sessions. Their chair is pushed out, and a strict legal boundary is drawn between them and the rest of the organization. That is the precise situation Colette McNally found herself in. She was a duly elected board member of Lakes Homeowners Association, a large Arizona nonprofit. Yet her own board systematically locked her out of executive sessions for years. This creates a direct collision between a representative's right to govern and a corporate entity's duty to protect itself from internal liabilities. To force her way back into the room, McNally took the HOA to Maricopa County Superior Court, filing a claim for breach of contract. The litigation tests a very specific question. Can a corporate board legally quarantine an active elected director from confidential meetings without violating the statutory rights attached to that office? By tracing the filings in this specific docket, we can see how a corporation builds a fiduciary firewall against one of its own, and how difficult it is to tear that wall down. To navigate the timeline of this dispute, we look at the joint hearing statement filed in August 2015. This document forces both the plaintiff and the defense to agree on a single set of facts before going to trial. The baseline is straightforward. McNally was a homeowner who successfully ran for a 3-year term on the 7-member Sun Lakes board in 2011. The conflict triggers on August 4, 2013. A former employee sends an email to McNally, copying 3 non-board members. The message accuses 2 of her former colleagues of misconduct. 1 month later, the board convenes a closed executive session to address the fallout. They pass a formal resolution disavowing the email entirely. McNally is the sole dissenting vote. The actual breach of protocol happens later that same day. During the open session of the board meeting, McNally reads the accusations from that email out loud to the attending community members. The corporate retaliation is swift. On September 11, the HOA's general counsel sends a letter recommending that the board screen McNally from all future executive sessions. This lockout was not temporary. McNally's term ended, she was re-elected to a second term in 2014, and the board continued the active screening process throughout her new mandate. While both sides stipulate to this sequence of events, the legal authority for a board to permanently silence a community-elected representative remains highly volatile territory. Locked out of her own meetings, McNally filed for equitable relief, asking the court to immediately intervene and restore her access. Her primary legal position relies on statutory rights. She argues that the HOA lacks the statutory authority under Arizona's open meeting laws to screen an elected official. Her brief points out a structural flaw in the board's logic. An active director cannot perform their sworn duties if they are systematically blinded by their own organization. The HOA counters with the concept of corporate trust. They argue McNally's decision to publicly broadcast internal allegations was a betrayal of the organization. Specifically, the defense claims her actions violated the fiduciary duties of loyalty and confidentiality required of all corporate directors under Arizona law. The presiding judge is left to weigh 2 opposing mandates: enforce the result of a democratic election or enforce the corporation's right to operational security. McNally's first maneuver was to file a motion for summary judgment, attempting to bypass a full trial and force the board to open its doors immediately. A court will only grant summary judgment if there is no genuine issue of material fact. The moving party must prove the evidence is so one-sided that no trial is necessary. In February 2015, Judge James Blomo issued a minute entry denying McNally's motion. The judge reasoned that the core issues, the email's confidentiality and the screening's necessity, were material facts upon which reasonable people could disagree. Denied a quick victory, McNally shifted to her backup strategy, an application for a preliminary injunction to restore her access while the lawsuit played out. A preliminary injunction requires the plaintiff to pass a strict 4-part test. First, McNally had to prove a strong likelihood of success on the merits of her underlying case. Second, she had to demonstrate the possibility of irreparable injury, meaning the harm of being locked out couldn't be fixed with a financial payout down the road. Finally, she had to prove that the balance of hardships tipped in her favor, and that granting the injunction supported broad public policy. After an evidentiary hearing, the court issued its order in October 2015. The judge denied the preliminary injunction outright. The procedural rules functioned as intended. Courts will rarely issue an injunction to force a board to accept an alleged rogue director while the facts of their loyalty remain legally contested. McNally immediately escalated the dispute. She appealed the denied injunction, transferring the record from Superior Court up to the Arizona Court of Appeals. Over the next year, her legal team expended significant resources. They filed certified transcripts, drafted extensive reply briefs, and formally motioned to accelerate the appeal. The appellate court granted the exoneration. The bench set an oral argument for September 2016, positioning the court to issue a definitive ruling on an HOA's power to screen directors. And then the litigation abruptly stops. Like many complex civil cases, it ends in a sudden settlement. In November 2016, the parties filed a notice of settlement, and the entire action was dismissed with prejudice. Because the case settled before oral arguments, no appellate judge issued a final opinion. The absolute legal boundary of an HOA's right to screen an elected director remains a gray area. While the final boundary remains legally undefined, the record demonstrates that a defensible fiduciary firewall, backed by the rules of civil procedure, can effectively withstand judicial interference.